is Keith Jackson. I am the moderator for this webinar on complications and legal ramifications in spine surgery. I would like to thank our guest, Timothy Linkus. It's very unique to get this opportunity to ask these kind of questions to a lawyer who specializes in medical malpractice. So we're going to structure this a little bit differently, and I hope that change is beneficial to the audience. These are our disclosures. Neither Tim nor I have anything to disclose. If you enjoy this course, or this is a topic that interests you, or that you feel like you need to know more about, there is a wonderful in-person offering through the AO that's been going on for several years now. This year's event is August 26th through 27th in Boston. It's Tim is going to be there as well. I've heard that it's a lively conversation, but it's all about managing complications both clinically and ethically in spine surgery. And I can't plug this event enough. So put it on your calendar if you're free. This is the standard content validation statement about AO and AO North America. Please take a chance to read it. 2 years into the pandemic, we're probably all Zoom experts by now, but please have your microphones muted and your video cameras turned off. Send all questions or technical issues to the Q&A box. We will review the questions and answer them. There is going to be a huge component of question and answers. We've set aside probably 30 minutes at the end for people to ask real life questions or things that they've heard about to Tim and get some advice, hypothetically speaking, of course. So getting into the topic at hand, medical malpractice is a huge system in the U.S. It accounts for approximately $55.6 billion of annual healthcare expenditure. That represents 2.4% of healthcare spending in the U.S. Spine surgery is one of the most litigious medical subspecialties in the system itself. Despite this, many spine surgeons receive little to no formal training on this topic during medical school or postgraduate medical education training. So the purpose of this is to improve surgeon understanding of the medical malpractice system and to begin to develop reasonable strategies to lower the risk of litigation in our practices. Please take a moment to familiarize yourself with the learning objectives. So by way of agenda, we've done the welcome and introductions. We're going to ask some polling questions that where we're going to get a chance to see what everybody's level of experience and familiarity is in these topics. Then I'm going to hand it over to Tim, who's going to define some of the definitional terms to help us kind of speak as much legalese as we can in 3 or 4 slides. Then I'm going to present one of my cases that didn't quite go as expected, that was potentially litigious, and hopefully that's going to draw out some of the key points so we can reinforce these learning objectives. For the last 25 to 30 minutes, we're going to open the Q&A session, and hopefully the participants can have questions burning questions that spark discussion. I think this is going to be a more interactive webinar than what we've seen in the past. So please start formulating your question. There's no such thing as a bad question, particularly when I've got 30 minutes of time to fill. So please hammer them away. Thank you. And then we're going to do a summary and wrap up, and we'll adjourn at about 9, trying to keep it in the 1 hour time frame. So polling question number 1, and I'd appreciate everybody's honest responses to these. Have you ever been involved in a medical malpractice claim? All these answers should be anonymous, and just click on the appropriate response. Okay, so this from the 40 responses we've got about a 45-55 split of people who have and have not. I would tell you that the literature suggests that the longer you stay in spine practice, the more likely it is that you're going to be in the yes category. And so very representative of our field that the majority of people, or near a majority of people in this webinar, have been involved in a claim. Polling question number 2, have you ever given a deposition? Okay, so again, about 45-55, for about a 45-55 split. This is one of the more common ways that we gain our first or our initial contact with the legal system. Polling question number 3, have you ever performed a wrong site or wrong level surgery? Okay, so about 1/5 of people have performed a wrong site, wrong level surgery. So, which is, not probably an unrepresented answer. Polling question number 4. On a scale of 1 to 5, rate your knowledge on your state or country's medical malpractice system and process. Center of mass seems to be between somewhat unfamiliar and somewhat familiar. And I think it's interesting that, though a lot of the initial questions about our contact with the legal system, we're close to a 45-55 split or 50-50 split, yes and no. That the most common answer here is that most people are unfamiliar with the system, and so the legal system, every case we do, it could potentially be a claim. So I think there's some real value in gaining a better understanding.
I might just jump in here real quick and just say that those numbers stood out to me as well. And what it tells me is that there are, among our participants anyhow, people who are involved in a malpractice case or have been and still don't feel familiar with it or neutral about it. And that can sometimes be a result of your lawyer. It may just be fear of the system and not wanting to take hold and control of the system. But that's an important, I think that's an important reflection of why these types of seminars are important. And I would encourage, I'm going to double down, Lynn, and say that if you've never been to the complication course and the one that's coming up in August, clear your calendar and come.
Yeah, I completely agree. Informal, most formal medical education programs, whether it's med school or residency, does not have a special course or curriculum developed towards the legal system. So it is something that you unfortunately have to learn through experience. I'm going to hand it over to Tim, who's going to go through some of the terminology associated with litigation and malpractice.
Yeah, so I could spend a couple hours or maybe even a full day talking about terminology. So I'm going to try to keep this somewhat brief, but by the responses, I can tell that about half of the people listening have been involved in unfortunately with one of these, and about half haven't. So I'm gonna try to remain general, and we'll get in more detail later. I begin by saying this: if you are a spine surgeon, there are two types of spine surgeons: those who have been sued and those who will be sued. So these terms are important, and how you deal with them are important as well. So generally, there's a claim, and a claim can mean different things. And if you've been involved in a lawsuit or you've had a claim, you've undoubtedly had to answer questions from hospital privileging standpoint or boards of medicine standpoint. And you have to understand the difference between a lawsuit, a claim, or a patient complaint, because how you answer that question will matter when you're recredentialing or applying for privileges for the first time or applying for a license or license renewal. And if you have questions about that, I think my contact information is on the slides. Please call me and ask me because it matters, the wording of that. And you may be reporting something you don't need to report. So a claim is just generally the way we define it in the legal field. It can be a written or an oral demand for money as a result of alleged malpractice. That's all it is. It doesn't have to be a lawsuit. You don't have to be served with any papers. It's just a written or oral claim for money based upon an alleged malpractice. And whether it's written or oral makes a difference on, again, reporting, or if you settle one of these claims that's written or oral, some are reported to the data bank and some aren't. So I could spend time and I can answer questions in the question answering if you're interested in learning more about that. The claimant is the patient generally making the claim. If the patient passed away, then it would be the estate or a representative of the estate making it. That is the claimant. The respondent is you if you're being sued or have a claim made against you. Not a defendant in the claim stage. You're a defendant only after process has been served, after a lawsuit has been filed. And that gets us down to the next term, and that's the claim stage. The claim stage is the period of time between the time the claim rolls in and the time a lawsuit is officially filed, that period of time. Frequently, you will be aware of an incident, a complication, an untoward outcome that you think might resolve in a claim, and you may be preparing for that before the claim is made. That is not necessarily the claim stage, but it's still an important stage. Look at the next slide. All right, so we hear this word negligence bandied about, and negligence is the same for a doctor as it is a lawyer, as it is for a plumber or an electrician. And that is simply the failure to take reasonable care, reasonable actions. So in medicine, it's either you failed to provide reasonable care, or it would have been reasonable to do something you didn't do. That's an omission. Medical malpractice is simply a fancy term for medical negligence. And we often think that medical negligence is different than that which we're charged with when we drive a car. The duty is actually the same. And the duty, doesn't matter what state you're in, there may be a heightened duty, but the basic duty is just to provide reasonable care. Not perfect care, but reasonable care. So when we talk about wrong site surgeries, as we're going to do here in a moment, I do believe it is possible to defend them, even if they are wrong site surgeries, because you can undertake reasonable precautions and still misidentify the level or the site. And despite all reasonable steps, that can happen. That is not negligence when that happens. And then the lawsuit is the actual pleading that's filed that initiates the entire complaint and the civil litigation. In different states, it's called different things. In my state, it's called a complaint. In some states, it's called a writ. Sometimes it's called a petition, but nevertheless, that's the official filing with the court. And that's when the patient or the estate becomes the plaintiff and you become the defendant. Go to the next one. All right, the elements of a medical malpractice claim or lawsuit are the same just about everywhere in just about every state. It's duty, breach, causation, damages. That's it. Duty, breach, causation, damages. And we're going to talk about each one of them because I think it's important for you to understand them. But first, I want you to know this. With the exception of a few very narrow occasions, the person suing has the burden of proof. You don't have to prove anything. You literally don't have to put on any evidence whatsoever. You don't have to call an expert. You don't have to call any witnesses in your case in chief. You may be called as a witness in the plaintiff or patient's case, but they have the burden of proving that malpractice was committed. Now, clearly you are going to defend yourself. You are going to call witnesses to rebut their evidence, but they have the burden of proof, and that's important. Let's look at the next slide. All right, so the duty is the standard of care. And the fundamental concept in a medical malpractice case is that there's a physician-patient relationship or a healthcare provider-patient relationship if you happen to be a PA or a nurse practitioner. So without that physician-patient relationship, there is no malpractice. And that's important. Some of you may do what's called IMEs or independent medical examinations. You want to make sure that you contractually define what you're doing in those occasions so you do not establish a physician-patient relationship in such that you can be sued by the person you're performing an IME on. Most of these arise in the context of you in your office or at the hospital performing surgery, and you have a physician-patient relationship. That's important. The standard of care is defined by a particular state, usually by statute, sometimes by the courts, but usually by statute, meaning the legislature defines the duty of care. But again, you can have, in West Virginia, I can cite it to you. It's the standard of care is to do that which a reasonable, prudent physician would do under the same or similar circumstances, acting in the shoes that you are. So you have to have similar training, essentially. That's different from state to state, but it's still reasonable care. So to summarize, the standard of care, which they have to prove, is to act reasonably. Let's look at the next slide. All right, so they have to prove what the standard of care is. And I should go back, and you can stay on this slide and say, there is not a list of do's and don'ts. We know that Medicare and JACO have never events, but there are no lists of do's and don'ts that represents within the standard of care or outside the standard of care. It's just what reasonable care is. They have to show that you failed to act reasonably in some way, shape, or form. And that's what we call a deviation from the standard of care. So they have to prove duty, and then breach of that duty, meaning you did not act reasonably. And I have this note down here, and I want to say this because I saw about half of you have given depositions before, and you might give a deposition, frankly, in a car wreck case. Your patient was out in a car wreck, they came to you, you performed surgery on them, and they're suing someone else in that motor vehicle accident. You may be under oath giving a deposition. I want everyone on this presentation to listen to this and hear this. Anything you say in that deposition can be used against you in a future case where you've been sued for medical malpractice. So what you say in that deposition, because it's sworn testimony under oath, is important, because someone may get a copy of that sworn statement and use it against you when you get sued. And so when someone is asking you about what standard of care is and isn't, remember, a lot of people, especially when you're being sued for malpractice, the opposing counsel wants to elevate the standard of care. They want to make it to a duty that you cannot meet. They want to establish a duty of perfection, a duty of patient safety, of needlessly endangering patients. And once they trick you into agreeing that the standard of care is to protect patient safety or never to needlessly endanger patients, whatever that means, then they can get you each and every time. So you need to know what negligence is not, and that is simply this heightened duty. The duty is simply to act reasonably. Let's go to the next slide. All right, causation. Causation is an essential element to any medical malpractice claim. Without causation, there is no actionable medical malpractice. Excuse me for just a second, I'm gonna mute myself while I call. I apologize. So what that means is this: you can commit negligence and fail to act reasonably, but it might not cause harm to a patient. So for instance, I may intend to order a specific antibiotic postoperatively following a patient's care, but I, for whatever reason, wasn't thinking that day, and I ordered an anticoagulant. Oops, I order, and they pick up an anticoagulant and take it for a week. If that anticoagulant did not cause them harm, and they didn't get an infection because they didn't have the antibiotics, there's no malpractice. Yes, you failed to order the right medication, but it didn't cause harm. So generally, you'll hear this in the term of approximate cause, and that's what we're talking about there. And then there are some states like mine that recognized an increased risk of harm. So it's not, did that actually cause the injury, but did your conduct increase the risk of harm to a patient? That gets complicated. Be happy to talk to anybody offline about it. Let's look at the next slide. Damages. Excuse me while I cough once again. I apologize. I got this cold. All right, sorry about that. Damages. So you have to have duty, breach, causation, and then damages, okay? So you can have cases, and I've defended them, where a physician has breached a duty, and it has actually caused an injury, but really there were no compensable damages to the situation. In other words, they're going to seek money damages for the injury or harm. And so that is what we're looking here. There are basically three types of damages in any lawsuit. They're economic, non-economic, and punitive. Economic damages are very simply defined as anything that you can go to the marketplace and place a value on. So for instance, if I'm your patient and I can no longer work and I have lost wages, I was unable to work for 3 weeks. Well, you can go to the marketplace and put a value on that. So I can claim that as damages. Funeral expenses, loss of household services, that can put a value on my services around the house to my family. And so if I'm unable to do that for 3 weeks as a result of your negligence, I can claim the value of that. That's economic damages. And then there are non-economic damages, which are things you can't go to the marketplace and put a value on. My pain. I was in pain for 3 weeks. Well, what's that worth? The market doesn't tell you that. My suffering, my loss of enjoyment of life, if someone's dead, loss of consortium. And that is in the exclusive province of a jury. And juries come up with a number. And then there's the final type of damages, which are punitive damages. And that's something to watch out for, because most insurance policies do not cover it. So each one on this phone call should have medical malpractice insurance. And the vast majority of you will have medical malpractice insurance that does not cover punitive damages. Punitive damages are in addition to compensatory damages. They're intended to punish, because the conduct is so egregious, it's so reckless, that some laws, some states recognize an additional method of damages to punish the defendant, to teach them a lesson. You don't want to be in a position of that claim. All right, we can go to the next slide.
Okay, so
Maybe just stop there a second, Tim, if you will. And if you can explain that a little bit more. So, you say that most malpractice insurances don't cover that. Like, how do
Correct.
we as surgeons protect ourselves from that? Like, does our university cover us? Where do we get protection for those sorts of damages, which are unpredictable?
That's a great question. So I was thinking about this earlier today. There are probably participants in this call here that are in private practice, maybe self-employed or working for someone else. There may be people working for the VA, and there may be people working at universities. And each situation is different. So for instance, I represent West Virginia University. I'm from West Virginia. I represent the physicians there. Their malpractice insurance actually covers punitive damages at that university, and they're immune for any damages beyond insurance coverage. And different universities have different policies. So to find out whether you're covered for punitive damages, you would need to actually contact the insurance agent or the insurance company writing the policy. You can get a copy of the policy, but you're going to read it and say it's all legalese. You can send it to me. I could tell you if it's covered. But your agent or your person who brokers your insurance should be able to answer that for you, whether your punitive damages are covered. But the vast majority of private insurance companies do not insure punitive damages.
And so as a result of that, should most of us have a backup policy? And if so, like, what typical value would you put on that as a spine surgeon?
So no malpractice lawyer who wants to get sued. Okay, I don't want to get sued. So any malpractice lawyer would say, "Oh, always buy extra insurance," right? I mean, that would be the standard operating procedure. Buy extra insurance. It might be hard to find a policy that actually covers punitive damages if you wanted to go to the marketplace and buy that. But here is a fact that is widely true. So the vast majority of the time, 98% of the time plus, the person suing is not after your money. They're after the insurance company's money. So if you have say $1 million policy and you have a bad outcome, they're going to take that $1 million policy somewhere along the line. If you have $2 million, they're going to litigate until they get that $2 million. If you get $3 million in coverage, they're going to litigate until they get that $3 million. So what I find is this reverse economic factor in this, and that is, hey, if you go and buy that extra policy of insurance, you may make it more difficult to resolve cases. Now, having said that, more protection's good, right? And that's why lawyers recommend you get as much as you can. But the punitive damages claims are when the conduct is pretty egregious. Most courts don't allow those to go to a jury unless the conduct is indeed egregious. So, if I were suing a physician and because you had operated at the wrong level, I would claim punitive damages. I would say, look, that's so egregious. I mean, everybody knows. I mean, every lay person knows you should never operate at the wrong. That's a never event. And so there's no way you could even say that's close to being reasonable. That's reckless conduct. You should be punished and taught a lesson. There's where a punitive damage claim could be made. And depending on the law of the state, West Virginia, we just ratcheted up the difficulty of getting these to a jury. It just used to be reckless conduct. But now they have to prove a deliberate, intentional, or reckless disregard for patient safety. That is really a tough burden to prove, a reckless disregard. So your question is, how do you find out? You need to ask your insurance agent or broker if it's covered. And no, you're not going to be able to probably find an insurance policy out there specifically written to cover punitive damages. I'd be surprised if you did. You might be able to, and it's going to probably cost a little bit. Now, I would be interested. Let me just tell you my experience real quick, while we're talking about that, Rick. I've been defending cases for 22, 23 years, tried, 75 to 100 cases for physicians. I have never, ever, ever seen from my clients, a plaintiff's attorney go after the personal assets of a physician. I've seen it 2 other occasions where they did. And both occasions, it was pretty egregious conduct. And so they did go after their personal assets. So you need to look at the limits of damages in your individual state and make sure you have sufficient insurance given the level of damages allowable under the law.
What is the usual across the country? I mean, obviously, as you suggest, every state is different. Is there like a common sort of rough number?
There is not. So there are states, I believe Texas might be one of them. There are states that cap all damages at $250,000. There are states like Virginia where I'm licensed to practice. I believe the cap might be up to $2 million on, and I think that might be just on non-economic. West Virginia caps there is no cap on economic, and they cap non-economic on major injuries to 750,000. So it literally is all over the map. And there are some states I understand without a cap. So let me, and I'm going to talk about this, hopefully, if I'm given the opportunity. I see John Devine's on there, so he's going to take notes on this. But in August, I'm going to present, hopefully, a case that was a verdict that was just rendered against a spine surgeon in my state for $17 million. He had $2 million in insurance coverage. I'll talk about the caps. I'll talk about the allegations, what went wrong at trial, what went wrong with the injury, the paralysis that occurred, and that sort of thing. So if you're interested in talking about that more, clear your calendars and come in August.
And while you're on that theme, I'll equally give a plug. For those that can, this is a great opportunity. Every case that's discussed at this complications course is something that is potential litigation. And we get to discuss it from a medical standpoint in terms of how to handle it. And of course, Tim gives tremendous insight in terms of how to document and how to deal with that. So if you all can make it, please plan on coming to Boston.
So we're going to jump into an illustrative case that will hopefully help us drive home some of these concepts. And I like this case because, Tim and I wrote a paper about 3 years ago that was published in the Global Spine Journal that was really just looking at doing a literature review on medical malpractice and what the literature is in spine surgery. And it turns out that most cases of litigation, most claims made against spine surgeons are not two-level PSOs in T4 to the pelvis cases. They're actually the most common cases we perform. And so most of them are in the lumbar spine. Most of them are discectomies. And that's what this case is. It's a single level, straightforward lumbar discectomy in a young, healthy person. And it also is one of wrong level surgery, which is a relatively common claim for spine surgeons that can be pretty hard to defend. And so this is a 42-year-old male that presented to the office with a 3-month history of left leg pain and weakness. He'd been tried and failed some non-operative modalities to include oral medications and physical therapy. He's relatively healthy and hadn't had any kind of spine surgery in the past. On his exam, he had a left straight leg raise and 4 or 5 strength in the left EHL. The rest of his exam was relatively unremarkable and normal. His x-rays show some diffuse degenerative disc disease in the lumbar spine, but no instability or deformity. On MRI, he had a large left paracentral disc at L4-5 that we identified. We discussed, just like a standard surgeon sort of thing, discussed risk and benefits of surgery. After that, he decided to have surgery. Unfortunately, he was the 3rd or 4th surgery scheduled for a day where we had inclement weather and a late start. As a result, his case was delayed to the following day. We tried to keep him within a reasonable schedule time frame because his spouse had taken off work to provide some immediate postoperative care. So did this case during lunch between morning and afternoon clinic. Intraoperatively, like we always did, I typically sign the side of the back where the disc is located and the leg pain is. Obtain a X-ray with a Woodson under a lamina to sort of verify the level. And here's the intraoperative image. If you scrutinize it closely, I think you can see where this is going. Once we did the hemiliminotomy, took down the ligamentum flavum and found the nerve root, retracted it over and didn't find a massive disc herniation that we had expected. Small disc bulge. I initially had assumed that that was because of the age of the MRI. It was about 3 months old. He got it within probably 2 or 3 days of the onset of leg pain. I thought he had probably resorbed some of it and certainly decompressed at the end of the surgery. In the PACU, I examined him. He was plus or minus, said his pain may be getting a little better, hard to tell when he wasn't standing up or leaning forward. So he's discharged home, came in for his 2-week wound check and said that, gosh, there is not, that surgery did nothing. A little bit concerned there. That's normally not the story, especially when I'm pretty confident that we've had a good decompression. And so I updated his MRI. Unfortunately, the axial of the MRI is there. But it also showed a hemiliminotomy at the L3-4 level. Talked to the patient, talked to him about what had happened, kind of showed him even some of the intraoperative images that we have from fluoro over the localizer. Elected to go back to surgery, and I did so within the week. Made sure to get the Whitson down a little further so we could actually verify that we were at the 4-5 level, found the large disc herniation that we expected, and he did quite well afterwards. So, Tim, I guess my questions for you are, what now? I'm sure that most of the time surgeons don't engage you immediately after they do their post-op check. But if I had, what would you tell me?
Yeah. So I do get a few calls right after the post-op check. But so number one is I would ask you, what did you tell the patient? And you make sure, because you would be surprised, maybe you wouldn't be surprised, how many people don't tell their patient on the first post-op visit, and they might say, hey, we need to go in and do this, and then I get a call. So you got to make sure that you're honest and upfront with the patient right from the get-go. You need to tell them, why that happened. In this case, we took reasonable precautions. Here's the X-ray. This can be tricky, and this is not a perfect science. And so we're going to go back in and correct it. That was the right thing to do. And then you went back in and corrected it, and he's doing well. So I'm going to assume he's not going to bring a lawsuit of any type because he's doing well. And really, frankly, if I'm a plaintiff's attorney on a case like this, it's not one I would take anyways. And I can speak to that. But number one, depending on whether or not you're in a VA, you work for a university, or you're in private practice, you have different considerations. You need to tell someone. Okay, you need to tell someone. So number one, if you work at a university, you need to tell your risk manager. Or if you work at a VA, they have a similar person in that position, a risk manager. You don't generally have access to your own insurance company to do that. Your university takes care of that for you. All insurance contracts require you to inform them when there's a claim or a potential claim. And a complication of a wrong level surgery is a potential claim every day of the week. So you need to tell your insurance company, hey, I want to let you know I had this wrong level. This is what happened. Just reporting to you. There's no claim yet, but the incident has occurred. And I view that as a potential claim. The reason you need to do that is your insurance company can deny you coverage if you don't follow the contract you have with them and report the potential claim. Risk management needs to know in your university, and they can tell the hospital side or at the VA, because they have to do. And certainly the hospital has reporting requirements to JACO on certain things, such as, I would guess, wrong level surgery. So those are things you need to do immediately. And then if you're at the university setting, your risk manager will make the determination whether or not legal counsel needs to be engaged. And frankly, your insurance company will too. So I have a surgeon now that I'm representing, for instance, who discovered he had a nurse in his office reusing needles. Now it was not through skin; it was just to draw out some I think it was epinephrine, but nevertheless reused the epinephrine to put into another vial multiple times. Well, he reported that to his insurance company. They got me involved, and we've done a total risk assessment. We're ready for about 30, 40 claims to come in over this. So your insurance company will make the determination. You always have the right, though, to get your own legal counsel. I wouldn't say that you need to do that if you have this situation here, so long as you've reported it to your insurance company and your employer. Now, the other thing is this, while I'm thinking about it, I just want to make sure I mention this because it's something I frankly ran into recently with a client. If you do get a claim that arises out of this, and let's say they don't sue the hospital, they only sue you. Many hospital bylaws require you, if the incident occurred at their hospital, to report it to the CEO of the hospital as well. So keep that in mind, because you don't want to have a privileging credentialing issue or have med exec looking at you because you never reported a claim. So that's what you do immediately.
I think that segue through the first two sounds like engage legal counsel as soon as you become aware of a potential claim or a potentially compensable event is something we use in the DoD as more of a risk management tool. Do you in your practice have you seen strategies that have worked well or tend to be somewhat
Yes.
protective or things that successful people do versus those that are unsuccessful?
Yes, absolutely. So number one is being upfront and honest with the patient in a very nice way. You don't want to be flippant about it, and you don't want to go in and say, oh my gosh, I really screwed up. And there's a way to handle this politically, and most people know in situational circumstances, say, hey, look, this happened. Being upfront with you, we have a way to fix it. Let's address it. This can happen. This is why it happened. Sorry that you have to have a second surgery, but we're going to go in here and get it done, and everything's going to be the way we need it to be. That is really important. There are actually scientific studies on that and saying that mitigates claims. Two is this, and sometimes you don't have control over this, and sometimes you do. But the second thing is that we have found that when you offer to write off the medical bills for both surgeries here, that mitigates risk. You say, hey, look, this shouldn't have happened. So what we're going to do is we're just going to not charge you or your insurance company for this, and you won't have a bill. And they appreciate that. So that is a good strategy. What you don't want to do is say, gee, I'm really sorry. I got to pay you. I got to give you compensation somehow. So I'm going to not charge you. That's not it at all. You say, hey, you're going to have a second surgery. And so we're going to just not charge you for it and go forward. And that sort of has this, I like my doctor, told me the truth. We're doing it. He has a plan to address it. He's not charging. And you want to probably have closer follow-up, not suspicious close follow-up, where you're calling them at home and, every night and checking on them and that sort of thing. I don't mind calls. Say, hey, I have patients. They have my cell phone. Here's my cell phone. I don't mind that, but you don't want to be overly suspicious. I have seen cases where a physician pestered a patient following a bad complication, and that drove that patient to a lawyer. So you don't want to do that, but you do want to have closer follow-up. I think those three things help to reduce claims.
Is there anything that you see doctors or physicians do before surgery in terms of counseling or consenting, or does
It's a really good point. No, go ahead. You were going to
does
ask
the consent help you at all? I mean, is the question.
Absolutely. So generally, consents don't immunize you from liability. The only thing a consent can do is either hurt you or help you, depending on whether you're one of those surgeons who uses a generic consent with not much information, or you're someone who documents well and says, I discussed these with the patient, including the possibility of X, Y, and Z, the most common complications. And then you can always use that as evidence in a claim to say, because a jury, I'm gone beyond your question here, but a jury sees that and says, well, he talked to him about it, and it's documented not only in the consent the patient signed, but in the operative note under indications. It says that he went through it in the preoperative holding area again. And so now they knew that this was a possibility. So that helps you from a claim standpoint. But yes, on claim mitigation, 100% informed consent can and will mitigate claims later on if you do it right. Because I have been with my family for many informed consents and for myself. And when people don't know I'm a lawyer, it's coming in, hey, by the way, we're going to do this and blah, 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 blah. All right, you got it? Okay. And they move on. And yet I can look at the record, and the record is completely different than what they told me. It says all these risks and alternatives, and that was never discussed with us, right? So if you genuinely look a patient in the eye and say, look, I'm not trying to scare you off from surgery, but there are some, this is spine surgery. And anytime there's spine surgery, there are risks. And so when I tell you there's a risk of paralysis, it's a small risk. It is a risk. Or there's a risk of postoperative bleeding and a hematoma that can compress the spine. Or, there's possibilities like pedicle screws. We're going to go in and put these pedicle screws in. Sometimes they go a little medially, can actually invade the spinal cord a little bit. As long as it's not compressing, it's fine. But sometimes that happens because this is an imperfect science. You just need to be aware that these happen. And I have, tell them your track record. That's fine, whatever. But you need to say, so if they happen, that's an expected outcome, and we'll deal with it on the other side. We hope that it doesn't happen. But if it does, then we'll talk about it again. Now, on the flip side, you can now go back and say, remember when we talked about that screw going medially? Well, we had one. I think it's okay. It's going to be fine, but here it is. Or whatever the complication is, that did happen, and we're going to address it. And this is how we're addressing it, you know? And that makes a patient think, gee, the doctor told me about it. It happened. Not his fault. I'm going to go about my business and not sue it or her.
Tim, let me field a few questions your way that are coming through. You know, it seems like honesty is the best policy, but are there ever things that we shouldn't say to a patient regarding a complication or anything, or what's your advice on that?
Yeah. So I think that number one, almost all complications, almost all, occur despite reasonable measures. So you don't want to come out and just say, you know what, I really screwed up. You know, let me tell you, there have been physicians who've said that to patients. I've really screwed up here. I shouldn't have done this. I'm going to try to fix it for you. That is the wrong approach. Okay. It's how you deliver it. Hey, remember the complication we talked about? Well, despite reasonable measures, it happened. And now we're going to have to address it. And we're going to have to go back in. It was the wrong level, but no problem. We'll go back in here in 2 weeks and we're going to get it done. And we'll address that symptoms. And then hopefully postoperatively following the second surgery, they come out and they do fine. So you don't want to oversell it. You don't want to it's okay to say, I'm sorry that it happened and that you're going through this, but we're going to fix it. You know, we're going to go forward and we're going to get you going as best we can. So you don't want to, what I'm saying is you don't want to come out and say, gee, whiz, I must have been having a bad day and this is what happened, you know. You want to show them that you're a confident, reasonable physician, not an arrogant one, but a confident, reasonable. So yeah, I think there is.
What do you suggest, you know, for those of us that are in academics, you know, a fellow kind of drops an instrument, or a resident, you know, sticks a screw medially because, you know, you weren't necessarily paying attention. How do you handle those situations where you as the attending surgeon are responsible, but it wasn't really your fault? Like you sort of, you know, for whatever reason, a resident, a fellow, a PA, whatever messes up.
So, so I have my own philosophy on that, and I've just developed it over representing fellows and residents and even interns and attendings over the years. And that is, I always prefer that attendings step up and take responsibility because they are a fellow or they are a resident, they are an intern. And so I think you say, hey, look, you know, we had fellows in there and we were both working and this happened. And I mean, most patients aren't going to say, did the resident do that or did you? And so I don't think you have to volunteer that to the patient, but you say the complication happened. I personally think going before a jury, it looks better when a faculty attending stands up and says, look, yes, that was the fellow, but I was there, I was supervising, and I take full responsibility for this. It was still reasonable care, and these things can happen. It didn't matter if he was doing it or I was doing it. So there's still reasonable care, but I take full responsibility for his actions. A jury likes someone to take responsibility. They don't look at it and say, oh, well, I'm going to hit you hard now, you know? So I think the same is true with the patient. And while we're talking about that, Rick, you all can do your colleagues a favor. Now, if the spine surgeon down the street sends a complication your way and it's an egregious error, you have a duty probably to your board of medicine to report him for such an egregious error. But I have seen way too many times that lawsuits are initiated because the guy has a genuine complication, comes to a spine surgeon. He says, I don't know what that guy was thinking. This should never have happened. You know, and you don't have to say, go see a lawyer. As soon as you say, I don't know what that guy was doing here. This was the complete, I mean, that patient's going out and seeing a lawyer. So a large percentage of these lawsuits can be mitigated by what you say about someone else or what someone else is saying about you. Keep that in mind.
But how do you strike that balance? I mean, because, you know, obviously we all see things, we sit there and go, wow, you know, that really seemed out of bounds. And obviously there's a lot of gray zone too, but, you know, what is your responsibility to a patient and what is your responsibility to just sort of say, well, I don't really want to get involved? Like, how do you balance that?
So let's say that Dr. Jackson's patient comes to you after the first surgery and says, hey, this guy told me that he operated on the wrong level, and I'd like for you to look at it. And you look at some, so yeah, he did, and that can happen. And that happens to just about every spine surgeon if they've operated long enough. But we can fix that for you, and let's go forward here and fix this for you. And you're focusing on the solution rather than the past. And he said, well, but it's on the wrong level. I mean, didn't he do it? Hey, look, you're here. We are where we are. We're going to move forward. I'm not going to dwell on the past. That's how you deal with it. Now, if it is egregious, okay, if it is egregious, then not only you always have a duty to be honest with the patient. You're not saying, oh, well, he didn't operate on the wrong level, right? I mean, a patient comes to you and says, hey, Dr. Jackson operated on me 3 months ago. Dr. Jackson didn't catch his own mistake. Can you do it? And you take MRIs and you realize it was at the wrong level. You read his records and he clearly meant to be at the other level. You have to say, look, he was at the wrong level. That happens to every spine surgeon if they practice long enough. We're going to go back in and do it. You have to be honest with them and tell them what you found, but you don't have to say, that Dr. Jackson, I wouldn't go back to him because, and he was at the wrong level. I've never had that happen. Oh, you say that? He's getting sued. He's getting sued. So, but if it's egregious, I think you have a duty. I think you have a duty to tell the patient, look, this is egregious, but most medicine's not. Most is gray areas. Most of it's indications. I saw a question pop up that we might talk about here in a minute. A questionable operative patient, because it sounds like the patient was pretty sick. Well, those are gray area judgment calls. It's easy to Monday morning quarterback those things. And that could be you one day. So if it's egregious, yeah, tell the patient, yeah, this is bad. I mean, they offered you surgery from the front, and you never make this approach from the front. This is always, a different approach, and nobody's done that in 30 years. And if that's the case, you need to say it, because that surgeon should not be doing that approach and might be doing it on other people. And that's dangerous.
Do you find that there is ever a situation where you say, you know what, don't take this to court, you should pay out? And what is that balance between saying, hey, fight this tooth and nail and go to court and fight all you can with all the expenses involved, versus just sort of say, cut your losses and spare all that and spare the shame?
Yeah. So yes, the answer is yes to your question. Every case is unique and there is no general answer. And so, if we look at the participants who said they've been involved in a lawsuit in the past, it looked to be about 45 or 50 people. And I don't know what your lawyers told you, but every case is unique. And you cannot have a general rule, fight tooth and nail. Even if the medicine's good, that can't be the general rule. Because I'll tell you why. You and I are human beings. We have emotions. We have a professional and a personal reputation that can be affected by a lawsuit, by settlement and going to trial. Okay. So I'll give you an example, a recent example, a case that I could defend all day long on behalf of a physician. I could defend it all day long. He wanted to defend it. This guy's a fighter. He has won everything he's ever fought. I mean, he is a fighter. And he's a great guy. I like him. But his wife developed cancer. And she was going through treatment, and he wanted to fight. She wanted to fight. And he was having to give a deposition and leave her in North Carolina to come back. And I finally sat down with him and said, look, I'm not going to tell you his name. I said, look, there are some things more important in life than fighting a lawsuit. And your wife is teetering, and her cancer is metastatic. I mean, she may not live. And fighting this battle in the middle of fighting that battle, there is a battle that's more important. And you know what? There's a death case. They wanted 25 grand from us. It was extortion money. I said, pay the extortion money. Go spend time with your wife. And you know what? I talked to him the other day. He said, that was the best piece of advice you ever gave me. I'm a fighter, but that was the best piece of advice. I'm so happy I paid the 25 grand. So yeah, there are circumstances, and everything's unique. So I have to take into consideration what you want, what your family dynamic, your professional dynamic, your personal dynamic, as well as what the insurance company wants. Because there are, and we're getting far afield, I suppose, but there are insurance policies that have consent clauses. The insurance company cannot settle a case without your written permission. And then there are a lot of insurance policies that don't have that. They can settle it with or without your permission. They don't care. So I have to take into consideration what they want. So there's a lot that goes into that analysis with no general rule. It really is. It's sort of like things are patient specific. That is definitely doctor specific in every case.
So Tim, you hit on the settlement aspect of these, which I suspect a number of them do go to settlement. But
Sure.
Is there any way you can walk us through, and I know that all states' processes differ uniquely, but is there any way you could walk us through just a general outline of a medical, an active medical practice occurs,
Sure.
claim, what next? And then how does this eventually go to resolution? What are the avenues?
Yeah. So from the moment a claim is made, before any lawsuit, from the moment that written claim for money damages is made, all the way up until after a jury reaches its verdict, all the way up to when it's appealed to the highest level of appellate court, the Supreme Court or whatever it is, before the Supreme Court rules, you can settle a case. There are opportunities to settle cases from the minute the claim's made to the very second before the last decision maker. I tried a case once. Jury came back, said, we have a verdict. Plaintiff's counsel looked at me, says, your last offer good? I looked at my client. He said, yes, we settled with the jury, had made a decision. We didn't even know what the decision was. Okay. So there's always opportunities to settle. So those avenues, those off ramps exist at every moment during the course of the claim and litigation. So what happens is that after a claim is filed, eventually there's a lawsuit filed. If it's an illegitimate lawsuit, they don't have a good faith basis for it, or there's another legal procedural reason, you can file a motion to have it dismissed. Those are rarely granted because most people who file these know what they're doing. Now, I should mention, and this is a good time for me to get on another soapbox, I suppose, is that these lawsuits cannot exist without you. And I don't mean you as a defendant. These lawsuits cannot exist without spine surgeons testifying against other spine surgeons. So if you have a case that makes it to a trial, that means a spine surgeon is testifying against you. So I think we do a poor job within our own professions, whether it be spine surgery, general orthopedic surgery, neurology, whatever emergency medicine. I think the specialties do a very poor job of monitoring themselves on bad expert testimony. There are many, many, many experts out there giving frivolous opinions, and you all do a very poor job of monitoring yourselves. So I say that the lawsuits cannot exist without you, not just because you're the defendant, because you're the experts too. Now, what was your question, Dr. Jackson?
Just the steps of the process. Yeah.
Okay. So and I did a presentation on this the last time in New Orleans. So it took me 3 hours to do it. So I'll try to condense it to 3 minutes. But it's after a claim that you enter a period called discovery, where you send each other written discovery, written requests for documents, written information. You do depositions, where you raise your right hand to swear to tell the truth. You have to identify experts, and you get to take depositions of experts. If you, as the physician defendant, make a mistake in your deposition and screw it up, they will win. You cannot win your deposition, but you can lose it. That's one of the ways out bad for you. Okay. And then I get to go take their expert's deposition. You can win the case by taking their expert's deposition. If I can challenge his opinions or her opinions scientifically, logically, rationally, or using my tricks, then I can maybe get you out on summary judgment based upon the testimony of their expert. Because if they don't have an expert, they can't get it to trial. So if I demolish him, then you win. So that's one way out. And at the end of the close of all the evidence, after all the discovery, all the depositions are done, you can file a motion for summary judgment. What you're doing is you're asking the court to find judgment summarily in your favor. And that is a possibility. Rarely granted. Most judges allow these to go to a jury. But summary judgment is an option. And then there's mediation. Most courts these days, in my state, it's mandated by statute that you must mediate. But most courts are ordering that. And that is an involuntary, voluntary process. So they force you to go, but they can't force you to settle. And what you do is you identify an independent third party that comes in and tries to go back and forth and say, well, Dr. Jackson, you operated at the wrong level. Do you want to offer any money? No. Okay, well, let's go over to the patient. Patient, do you want money? How much money do you want? I want $1 billion. Okay. Dr. Jackson, they want $1 billion. How about offering something? Okay, great. I'll offer $5,000. All right, he's offering $5,000. $1 billion is ridiculous. Oh, you want $1 million. And he goes back and tries to broker a deal. And if you do reach a deal, you settle and you're done. If not, you go on to a jury trial. And during the jury trial, if they don't put on sufficient evidence at the close of their case, they get to put on their case first. Then you can move for what's called a directed verdict. You ask the court to direct verdict in your favor because they had insufficient evidence. Those are rarely granted. And then you get to present your evidence. Then a jury determines the case. And of course, you have an appeal after that, and that whole process can start over again. That's a 3-minute sketch of something that might take me 3 hours to explain.
Can you talk a little bit about the National Practitioners Data Bank and how it fits into some of this?
Yeah, I sure can. So the National Practitioner Database is a scary term for physicians, I suppose, and it shouldn't be. It absolutely should not be. It's just a repository for information created by about 4 or 5 federal statutes. You take a few pieces of this statute together and you form it together, and you get the National Practitioner Database, and all kinds of information gets reported there. And it's just simply a repository for information. I basically say it keeps physicians honest. I mean, if you settle a case, then it gets reported to the National Practitioner Database as you having settled a case. So when you go apply for privileges, you can't lie about it because you know they're going to go to the database and find out about it. Well, you shouldn't lie about it. You settled the case, right? I mean, you got to be honest. However, a big however, there are exceptions, and we're talking about lawsuits. There are other things that are reported to the database. Actions against your privileges. You're under investigation and you voluntarily resign your privileges. That's a reportable event to the database. So there are other things, but let's stay in the context of claim here for a moment. There are ways to settle a claim and not be reported. So if you, Dr. Jackson, in this particular case you presented, it's worth very little. I mean, he had to undergo a second surgery and did fine. All right, what's it worth to undergo a second surgery where the medical bills were written off? What kind of pain and suffering? $5,000 maybe? You know, if you, Dr. Jackson, say to your insurance company, pay $5,000 on my behalf. All right, and that settlement agreement says Dr. Jackson hereby releases, or the patient hereby releases their claims against Dr. Jackson in exchange for $5,000, you get reported to the data bank. But if you, Dr. Jackson, paid that $5,000 out of your own pocket, it's not a reportable event to the database. Okay. There are other ways to get settlements that are not reported to the database. So for instance, you could do what's called high-low arbitration. And you agree to pay $5,000 if you win arbitration on the low, and $10,000 if you lose arbitration. Okay, I'm just making up the numbers. Make it 100, whatever. And then you go and you have an arbitrator decide the case. And if the arbitrator decides in your favor, you still pay $5,000, but there's no report to the database. There are other ways of doing it. If you're in a practice with more than one healthcare practitioner that can be reported, and the plaintiff only names your employer in the claim, and your employer is only the named releasee in the release, you're not personally named, and you cannot be identified either in the claim, well, you have to be both in the claim and in the release, then there is a possibility that you do not need to be reported to the database. I'll give you for instance, I represent a neurology practice. 3 of their healthcare professionals were alleged to be negligent in failing to diagnose a stroke. We settled it the other day for $75,000. This lady had a big stroke, convalesced for 3 months, racked up a big bunch of bills, and died. You know, the case, if we were liable, probably is worth $3 million. We settled it for $75,000. We settled it on behalf of the company that employs those 3, and none of them got reported to the database. Okay, so your lawyer should be familiar enough with the database, with reporting the exceptions, and those should be discussed with you. I always have that discussion with my clients. Dr. Jackson, I'm representing you. I'm not recommending this option to you because it's $100,000. This case is worth $100,000. But if you pay it $100,000 out of your pocket, it's not a reportable thing. I'm not recommending it, but you need to know that there are ways not to have this reported. Your lawyer should be discussing those.
Kind of a last question. You know, you've mentioned a couple of times the need for us as a profession to police our own, whether it's reporting people who are doing bad surgery or whether it's policing our expert testimony. But we sometimes find ourselves in a position of peer review, whether it's through a state medical board or whether it's through a hospital. What protections what protections does someone serving in a peer review role have?
So that's a great question. Most states, all of the ones that I've personally seen the law, have immunity for any person participating as an expert witness or for peer review. So if you're participating as part of the peer review committee, you have immunity in your actions. Now, there's a federal law that grants immunity to the hospital as well as the individuals on the peer review committee under federal law, so long as the hospital's peer review process follows certain steps in that federal statute. And most hospitals do mirror their policies and procedures. I'm actually representing a physician right now who's having his privileges revoked at the hospital. And they were trying to negotiate something, and they threw something in and saying, well, we're revoking it for this reason as well. And I said, oh, really? Well, that's great. Please put that in writing to me, because you did not give him a chance to respond, which is something you must do under the federal law. And that means you lose your immunity and we'll be suing you. You know, so I mean, if they follow that process, then if you're participating in it, if I'm on the peer review committee, I would want to make sure that my hospital is following that federal law to a T, because that gives you the immunity. Okay. Expert witnesses in almost all states have immunity for their testimony. That's why this goes unabated, because they can't be sued. I mean, we have doctors testifying at trial that come in and say, yep, the sky's red. I don't care what anyone else says, that sky's red. And there's nothing really you can do unless you have them prosecuted for perjury. And they may have prosecutorial immunity for that as well. So when you talk about policing yourselves, if I could find the panacea of taking care of experts who are testifying in my belief to be falsely, I would be a rich man. And I'm still looking for that business model.
The final question before we kind of get to the wrap up, but if an academician can be dropped from a lawsuit before it settles, should they be pushing for that instead of it going to trial? And who can help best decide those kind of things?
Yeah. So, you know, some institutions, some academic institutions do not like to have their physicians dismissed from the case. They prefer to be out there instead of the institution. The institution in my state, West Virginia University, wants to protect its physicians. It gives me the green light, and I can advocate all day long for the dismissal of the physicians. And I do it from the second that the claim is made up until the time of whenever. And I'm very, very successful at that. And your lawyer should. I mean, that is something that you asked about an academic institution. I think academic institutions should be protecting their physicians, and the institution itself should be named, not the physician. So you just need to find out what the policy is at your own institution.
So just to kind of get into the summary, a 4-element, Tim went over 4 elements. That's a duty, a breach of that duty, causation, and damages that result because of the breach. And so we had a lot of other great questions this evening. I'd like to thank all the participants, particularly those with questions. I'd also really like to thank Tim. You know, every time we've conversed, whether it's writing the paper or through this, I just learned so much about a system that honestly I don't have a lot of formal training with. So I'm sort of an involuntary participant in a system that I don't understand, and so it really helps to solidify that. We'll be on a little Army-directed trip during August, so I'd certainly be trying to get up to Boston to get the real deal. But I would encourage everybody on here to do that, to attend one of those courses and just maintain involvement in AO. There's lots of great offerings in the pipeline for these webinars.
Thank you.
Thanks, everybody, for attending.